Good evening. This is Rahul Reddy live here from Houston, Texas. Every week on Tuesday at 5 p.m. Reddy Neumann PC brings in business immigration updates. Along with me is my business partner, Emily Neumann. Emily, what do we have today?
Thanks for joining us. We want to talk about this idea of Nunc Pro Tunc. You've probably heard that phrase a lot, and so we want to give you an idea of what exactly it means, when you can use it, and when it's not a great idea to use it, especially when processing times are becoming very long for certain types of applications. We want to talk more about international students, F1 status, how to maintain that, common mistakes we're seeing. We talked last week about the issue of that some students are having when they're passing through the Abu Dhabi airport and being turned back due to some actions in their past and things that were found out from the CBP officer during the inspection. And so we want to make sure you're aware of common issues that come up and things that could run you into trouble later on so you don't make those same mistakes. We want to give you an overview of the different ways in which you might be able to change employers while your green card process is going on, depending on where you're at within that process and what the benefits and disadvantages are of making that type of job change while you're in that process. And a new study has come out recently that is showing very clearly the impact the Trump administration has been having on legal immigration without any changes in the law. So we want to give you an update on that and what we're seeing.
First comment that we got it from is Nunc Pro Tunc sounds like a kung fu movie. You're absolutely right. However, though, it's a Latin word, it's a Latin phrase. Mostly law is the basic law. There are certain principles that are there. We've been taught in Latin. I don't know why they use Latin words, but that's how we've been taught in law. What does a Nunc Pro Tunc means is that it is explaining that you fell out of status, not because of your mistake, but because of somebody else's mistake. And you're requesting the USCIS to excuse that you are out of status or your I-94 expire, to excuse you for being not in legal status. That status that you fell out of is not because of your fault, is somebody else's fault. Under the extraordinary circumstances, you can request the USCIS to excuse you for being out of status. Typically, we do that when a person, let's say, files a H-1B extension, his extension is denied, his I-94 is expired, and he may wants to file another extension after the I-94 expire. The extension was been denied not because of his fault, it is because of the employer faults, vendor fault, all different faults can happen. Of course, it's not so easy. You can request the Nunc Pro Tunc. There are times that we get the approvals, there are times we don't get the approvals. Emily is going to go a little bit more deep into it. But practically, Nunc Pro Tunc means that please excuse me for being out of status. It is not because of my mistake. The mistake has been done. It is beyond your control that you could have maintained the status. Otherwise, you could have maintained the status. Emily, I know we do argue Nunc Pro Tunc cases when people fell out of status. What are the kinds of times where we succeed? What are the kinds of places where we don't succeed? And what are the risks in arguing it? Mm-hmm. Is it good to go under normal processing or premium processing for this Nunc Pro Tunc?
Yeah, so a strong situation for a Nunc Pro Tunc argument is what we're seeing a lot of times with these shortened H-1B approvals, where you filed an extension requesting a 3-year approval. It takes them 6 months to approve it, and for some reason they only give you a 5-month extension, meaning that by the time you get that approval, it's already expires. There is absolutely no way you could have complied with that situation. USCIS puts you in that situation through no fault of your own. There's nothing your employer did. And so if you file another extension, it's technically late by 1 month, but USCIS has the discretion to overlook that gap because there was clearly no way you could have properly complied. You had no way of knowing that when that approval came, it would have already been expired. So that's a good example. Another good example that used to work is the situation where you filed your H1 extension or your L1 extension, and through some miscommunication with the attorney, everybody forgot to file for the dependents. So the H4 was missed out on, or the L2 was missed out on, and nobody realized it until the H4 or L2 spouse or children went out of status and their I-94 is expired. That used to always be a common issue, and it's the most common Nunc Pro Tunc request, and it generally does work. However, the problems that we're having with Nunc Pro Tunc requests now is you don't know whether it's successful until you actually get an approval. That approval could come with a new I-94 saying, yes, we excuse your delay in filing or your late filing, and we're putting you back in status. Or your petition could be approved without an I-94, meaning that they've denied your request for Nunc Pro Tunc. Now you have to exit, get the new visa stamp, and come back to regain your status. For H4s and L2s, it's a bit of a risk now to do a Nunc Pro Tunc request because the processing time is generally more than 180 days. So you're already filing after the I-94 has expired, and we talk a lot about unlawful presence. You don't want to cross that 180-day mark. So for an H4 or L2, where the processing time of the Nunc Pro Tunc request itself is going to go beyond 180 days, the safer option would be to exit before you hit the 180 days and then just get the H4 or L2 stamp and come back in to regain your status. Now, if this is an H1 scenario where maybe you got an unexpected denial and your I-94 is already expired and you're trying a Nunc Pro Tunc request in that situation, again, the 180-day clock starts counting from the day of the denial, assuming your I-94 is already expired. So therefore, you need to make sure that you get a decision on your refiled application within 180 days. Current processing time, that might be unlikely if you're sticking with regular processing. So for that reason, a Nunc Pro Tunc request should normally be filed in premium processing so that if it is unsuccessful, you get that approval without the I-94, you have plenty of time to exit before you're going to hit 180 days. You can get the new visa stamp. There's no inadmissibility issues because you were not unlawfully present for 180 days or more, and you can come back to regain your status.
Emily, you said 100 times on this YouTube and Facebook that when the extension is pending, that it's the 180 days doesn't start counting. Why is that in the non-Pro Tunc case you're telling different story? You said 100 times before that when the extension is pending though, 180 days only starts after the denial, not when the extension is pending.
Right, and the difference is that in order for the unlawful presence to not begin counting, your extension had to have been timely filed. Here we're filing an untimely extension, therefore there's no tolling of the unlawful presence clock. It's going to keep ticking while your refiled application is pending because you filed it late.
What are the common mistakes now? We have seen that in the Abu Dhabi airport, good number of people have been sent back to their home country because of the mistakes what they have done at the time when they were in the student visa. At the time when a person is on student visa, and probably at the time of the OPT and STEM extension, it's not just that you are in the country, it's not that you are in the civil system. That by itself is not sufficient. There are certain things that you have to maintain the status. And there are certain things that, we see commonly people thinking that, oh, the other guys are doing, so I'm going to do the same thing. So you need to understand that there are certain rules and regulations for student visa. Student visa is given only for one purpose, that you come here, you study, and then you get back to your home country. However, we already know that there is an optional practical training. The reason optional practical training is being given is that to enhance the education that you have received in USA. It is good for you to work for a 1 year period of time so that it enhances your education. Let's say you're a law degree holder, but you never worked in USA. I mean, when you go outside the country, you don't have much understanding unless you work a certain period of time. And that's the reason why OPT has been given. And then if you have a STEM degree, like a computer science or any other sciences and engineering, you are allowed to up to 24 months after the 12 months of the OPT period that you're allowed to work for a E-verified company, and that the company has certain rules and regulations that they have to abide for. So everybody knows that in the student visa time, they have to go to college and attend the college. That part, we already know that. Now, obviously, there are some universities that are telling you don't need to attend the school at all. At Reddy Neumann PC, we always discourage. We don't believe those things at all. Now, that being said, that now in the OPT period, that means that optional practical training period, as I've described before, is that your education must be enhanced in the working. So if you have done a computer science degree, if you work in the software field, obviously your education will be enhanced. And that's one of the reasons why they have given the OPT. In the OPT period, it is not absolutely required that you must be getting paid. A training without pay may also be allowed under certain limited circumstances. But a clear documentation should be there that you're actually working or getting trained in the period of the OPT. Now, in the STEM extension, that means after the 12 months of the OPT, you have a 24 months of STEM extension. For the STEM degree people, you must still be enhancing your degree. You cannot work in a different field than that field for which you got the master's or bachelor's degree in. And you're allowed to work up till 24 months. You have to fill a 983 form. The company has to complete the 983 and make sure that they're complying with all the rules and regulations. They're maintaining the supervision. They're maintaining any training that is required in the STEM extension period. Also, all this should have a clear documentation with things going on at the airport, with things going on at the time when you file the H-1B, with things going on even further at a later time. You may be in a difficult time if you don't have the proper documentation. We strongly recommend that the training period that you took it, you have a strong documentation. A documentation, an employer letter by itself might not be enough. If you have any formal trainings that were being given and you have any documentation, keep that at a certain safe place where you can retrieve it when you want to. And do you need to carry it every time, all these 1,000 pages? Maybe, may not be, but if it's good to have it documented very well. We have seen a lot of problems on those things. In the STEM extension, there is, once you complete, there is evaluation that need to be done, that need to be completed. You need to get all those things done properly. The evaluation must be done personally by a supervisor. It cannot be randomly copied on for 100 employees, the same copy and paste it. That's not allowed. Emily, what are the other things where you have seen the students doing mistake in maintaining the student visas?
Yeah, I think that if we look at the regulatory agenda, we know that ICE is planning to make some changes to optional practical training so that there's more oversight. So they definitely are receiving information from students traveling and just from, I'm sure, part of their sting operations and all of that about how some students are able to circumvent the regulations. So I think what they're focusing a lot on right now is that initial 1-year OPT period when students are claiming that they worked without pay, and maybe they have the letter from the employer suggesting that. They're really second guessing that because they're seeing that some students just randomly get a letter from an employer who's helping them out without ever actually working, and they're doing it and submitting it to their school so that on paper it looks like they're maintaining their F1 status and doing the proper thing during their OPT, but they're not actually working. So if you're not getting paid during your 12-month OPT, although that technically is allowed, it may not be a great idea. It may be better if you have the option to continue searching for employment that is in a paid internship type of category. If it's going to be unpaid, as Rahul said, get documentation, keep documentation of all the work that you've done for that entire time, because they really are questioning into that at consular visa interviews as well as at the port of entry. So a question we get a lot is, I want to change my employer. I'm at part the third step of my green card process or the second step or wherever you're at in the green card process, can I change my employer? What's the impact on the green card? So let's go step by step. Let's say that your perm labor certification is filed and pending, and now you want to change your jobs. What can someone change their job at that stage while the perm is still pending, and what does that do to the green card?
They can change the job, obviously. There's nothing there that prevents them to change the job, but they will not be able to take the benefit of the perm labor certification that has been filed. Obviously, the only way that you can benefit for the existing application that has been filed is that the labor has been approved, the I-140 has been filed and approved, and it's been there for about 6 months period after, that's 180 days after the I-140 is approved and the I-140 is not withdrawn. That's when you will be able to benefit when you move out of one company to another company. But if the I-140 has not been filed or has been withdrawn within 180 days after the I-140 has been approved, you won't have the benefit of retaining the priority date. You won't have the benefit of having that to extend the H-1B. You won't have the benefit of that for your spouse, that you can use it for EAD filing. The crucial thing that you need to remember is the I-140 must have been approved and it's not been withdrawn within 180 days. There's a lot of questions that pop up with regards to this. Some people will say, well, I'm going to leave the company after 3 months that I leave. If the company does not withdraw the labor certificate, does not withdraw the I-140 until after 180 days, they have not withdrawn it up to 180 days. Is it valid? Yes. It's not that you must have been working for that company for that 180 days. The company must not have been withdrawn that I-140 approval. Also, questions comes in, can the employer withdraw the I-140 after the 180 days? Yes, they can withdraw, but it won't have any negative impact. If the employer withdraws it after the I-140 and it's been more than 180 days, you can still use that I-140 for all purposes, for filing a H-1B extension, even though it's been withdrawn by company A, because it's been withdrawn after 180 days. You can use it for H-4 EAD. You can port the date you can port the date to a new company with a new labor certification from the old labor certification. Anything I missed, Emily?
I think you caught everything there. So also wanted to talk about this new study that came out that's showing that a 7% drop in legal immigration to the United States from about fiscal year 2016 through fiscal year 2018, which of course is when the Trump administration came into office. And this is really interesting and obviously very sad to see, but especially because we've had zero change in law, very little change in regulation, yet we're still, what is causing this 7% reduction in the number of legal immigrants coming into the United States? And it's all about new memos that are coming out, new policies, new interpretations of existing law that are much more restrictive in trying to limit legal immigration. So Trump has talked about having this wall built to keep the border secure and all of that, but he truly has started building an invisible wall brick by brick that's blocking legal immigrants from coming to this country as well, even without any changes in the law.
So the only change that we have seen, the real legal change that we have seen in the regulation, is the lottery system. They changed the lottery system, which actually is a very good thing that they have done it. But the rest of the things what they have done is without changing any law, without changing any regulations, without changing, Congress has never even touched any of the business immigration, but still 7% down. 7% down, what Emily was pointing out is the number of green cards that have been given to the individuals though. If you look into the stats of the number of non-immigrant visas that got denied, that got revoked or got into trouble, it's staggering. It's not 7%, it's much, much, much higher. I would say that The percentage of denials has gone, I mean, the number of denials, not percentage, the number of denials has gone by more than 700%, not the 7% Emily is claiming on the immigrant visa, but the denials have gone definitely more than 700% since this administration has come in. What we request people is to get the decision of the non-immigrant visas that you have before your I-94 expires. You will have a lot of different options that you normally don't if the I-94 expires. That's the easiest thing that you can do. Certain times, for example, if you have an eligibility to file a H4 and your extension is still pending, and you haven't got a decision on the H1B, you may want to consider throwing an application for H4 too, to be on a different site. So there are a lot of things that before the I-94 expires, you may want to take up those actions. These are the only things that you have. Rest everything, you can't control those things. Whether SOW is only for 3 months or 4 months, of course you would like to have an SOW for 3 years, but you won't get it. So certain things you can take care of it. We would strongly recommend you take care of it.
Time for some questions?
Yes.
All right. Sharath from Facebook has a good question. He's finishing his master's degree in May and wants to know if he can file in the master's cap for the H-1B lottery coming up in April of 2020. So there's two ways to look at this. The first is if you are going to have completed all of the requirements for your master's in April, just not the actual graduation, and you can get a letter from your registrar that confirms that you've met all requirements for graduation, but the actual graduation date isn't till May, you can file in the master's cap. The other thing to think about is with this new lottery system, you'll know by March 31st whether you've been selected or not, and you have until June 30th to file your H1. So you could wait until you're graduated and get your degree certificate and then file. That way there's no question. So it's based on the date you're physically filing the H-1B petition, do you qualify for the master's cap? It's not based on when your lottery electronic registration is submitted in March.
One question that comes from the YouTube is that the person got the green card approved. Can he change the job? Can he move to a different job than the job he is? Once the green card is approved, yes, you do not have any restriction. You can move to a different job based on the employment. Let's say, for example, if you got a software engineer job and you want to go to a manager level, that's fine. Absolutely not a problem once you get a green card approval.
Bimesh from YouTube has an approved I-140 in the EB3 category from India back in 2016 and wants to know if he can now go for consular processing. So yes, you can. So consular processing means rather than remaining in the U.S. and adjusting your status by filing the 485 when your date becomes current, you're going to exit the country and proceed to obtain the green card through the consulate by submitting the DS-260, getting your medical exam done there, and getting all of the police clearance certificates. Yes, your employer that filed that I-140 has to file an I-824 application, which will allow USCIS to notify the consulate that you are now going to be seeking consular processing of that approved I-140. That's assuming that that same employer has that same job open for you and they're going to keep that job open for you. If you are instead thinking of filing with a different employer, you won't be able to use that existing I-140. Your new employer will have to file a new labor and a new I-140. You can retain the priority date, and then that I-140 can be consular processed if you're outside the U.S. at that point.
Emily, I may need your attention on what Janai Patel is speaking about. They have about 200 or 300 students.
Yeah, I was afraid you were going to ask me. I don't know the answer.
With the university STEM degree conversion issue. Janai, we do represent some organizations, people, student organizations, and also physical therapist organizations, teachers organizations, and consulting company organizations to jointly represent them in some of the issues. Emily has some experience representing in front of the state board with regards to the licensing issues of the people who have been getting, they're getting H-1Bs is getting shorter approvals, their license, so there are like chicken and egg issues. There are a lot of times we were able to resolve some of them. So yes, you may contact our office. We will try to look into it, but no assurances because the STEM degree conversion, we need to look into what was being told to you at the time when you joined, what are the courses that you have taken, and we probably need to discuss with the DSO to see what exactly happened before we can jump on and say, hey, you come to our office, we're going to just convert you into STEM degrees. No, that can't be. We need to look into more detail, need to discuss with the DSO to see if we will be able to help at all. Maybe we can, maybe we cannot, but I would recommend you contact us privately.
Yeah, I've seen a lot of schools kind of rethinking what CIP code they're assigning to their different programs, because they, obviously schools are wanting to recruit international students. They get a lot more tuition from international students. And so if they can convert an existing program to a STEM program by just changing the SIP code, then now they're able to offer STEM extensions to those students who come for that program. But Janae's specific question about, can students who already graduated from that program and are in OPT now, can they benefit from that? I don't know the answer off the top of my head. I need to look into the regulations, and we can definitely look into whether we can make an argument that you should qualify for the STEM extension as well. So feel free, Janae, to send me an email, emily@rnlawgroup.com, with some of the information, and we'll see if we can help those students for sure.
A lot of people, Sai Krishna and some other people, have this question, Emily, when will the electronic H-1B results be out? Is it going to be by March? And yeah, we for sure are at this point of time estimating that the lottery results will be out by March 31st. And then you will have 90 days to file the H-1B application after that. It may be out on 25th, it may be out on March 31st. That is somewhere between March 25th and March 31st is what we are estimating, where the results are going to come out.
Viral from Facebook has a question about changing jobs after the I-140 is approved. He wants to know if you can change the title from, for example, individual contributor to a manager level position. And I'm assuming the 485 has not yet been filed, so you don't qualify for AC-21. So it really does boil down to the duties of the position. If there has been a material change in the job duties such that it's really a different position being offered, then a new labor and new I-140 may be necessary for that type of change. If it's just a change in title alone, maybe the company's redoing their job titles and simply a title change where everything else remains the same, no change in duties, then it would likely not require a new labor or I-140 because it's not a material change. It really is a case-by-case looking at the individual circumstances, so difficult to assess that without any information.
Hari from Facebook has a kind of tough question. Can a person has two 485 application, he has already filed a 485 application, now the priority date for his wife is current, can he have a file as a dependent? If you're maintaining a non-immigrant visa status, for example, you're still on a H-1B or L-1, yes, nothing wrong with two 485s. It may confuse the USCIS office on the whole thing. There is nothing wrong in it. But strategically, there are some issues that we noticed when two 485 applications are pending. The USCIS system gets confused and it throws everything out. And that's where it creates a problem, though. That's the reason why you may want to consult a lawyer to see which one to choose. I mean, if it's, do you actually need to file a 485 with your wife, or you may not need it. If it's current for you and current for your wife, and why file another 485? Because the USCIS system doesn't allow it to take it. We have had some issues on that previously, and it took a long time to have any resolution on that thing. If you are on a non-immigrant visa and your current 485 is backlogged very much, yeah, you may want to file another thing and maybe withdraw the previous one. But if you're not maintaining the non-immigrant visa status, that definitely cannot be achieved. And maybe filing a second 485 will not resolve if you don't maintain the non-immigrant visas.
Praveen from YouTube wants to know about tourist visas. His mom was here on a B2 visitor visa last year, and she wants to visit again in January, and he wants to know if she'll have any issues at the port of entry. There can always be issues. Obviously, we don't know all of the specifics, but just because she was here recently and is coming back by itself is not an issue, but every time she's entering, she has to be able to convince the officer at the port of entry that the purpose of her entry into the U.S. is in line with the tourist visa. So she's coming as a visitor for tourism purposes, to visit family, whatever the case may be, that it's temporary and that she will return to her home country at the end of the visit. So if she can convince the officer of those things, then she should not have any issues at the port of entry.
Senate 386 bill, we get these questions all the time. At this point of time, it doesn't look to be the high priority for Senate to pass it. There's a lot of discussion on, things like impeachment and other things. It doesn't look to be a high priority. What our advice to all the people who is to approach the senators frequently and try to broaden the scope of the approach to what you're doing. Please approach their senators to have the Senate 386 bill, because this is the only bill that treats all immigrants in one way. They don't treat based on the country of birth. Please, when you do contact the senator's office, don't tell that this benefits the Indians or Chinese nationals. It does not. It just makes everybody equal. That's all we are asking for in this bill. And try to approach that way, which will be in much better situation.
Nikhil from YouTube moved from Company A to Company B after he already had his I-140 approved with Company A. Now he has his I-140 approved with Company B and wants to go back to Company A. So he wants to know if he needs to refile anything, the I-140 with Company A, assuming that they have not withdrawn it. And it all depends on whether it's the same job that you moved back to. Is it the same salary, same title, same job duties? And if they haven't withdrawn it, they do not need to refile anything. If it's a different job, materially different job duties, different title, different salary, if it's a different location, anything like that, they do need to do a new labor certification in I-140.
The admin NRIs are asking this question. Isn't it crazy to call the senators again? Isn't it kind of harassing the U.S. senators? I would definitely not recommend that people just keep on calling the senator's office day in and day out. If you want, our office does guide a lot of organizations. We can guide you properly how to contact the Senate. Emily has put on her blog in immigrationgirl.com a sample letter. We would like you to write them the letters that, look, I am working at this location. I am working as this. This is the amount of money that I am making. This is the house that I have. This is a mortgage that I have. This is where I spend my money. They will get it. When you say you have a house, you have a mortgage, your wife is working, your kids are going to the school, you need to explain all that in a letter and send it. Don't just keep on calling them again and again. It's not advisable to do that. It doesn't do anything. We have had a lot of organizations. I went into conference call. I met a couple of organizations, and they said, hey, you know what, every person call the senator from the different state and tell them they're living in that state. No, that's a lie. Don't do that. Absolutely not. Make a fair statement. Look, this is my address. Give them the address. Give them the address. Give where your children are going to school, how long you have been in the country. We are not requesting them to do anything extraordinary. We are not telling them to put you ahead of the line. All we are asking in the Senate 386 bill is treat you equally, just like Tom, Dick, and Harry. That's all. You don't want any special preference, just the normal way. So write the letter, especially use the letter that is being given by immigrationgirl.com, and write the letter, and have all your friends who are affected write the letters. If there are any teenagers in the school, you may want them to write the letters. Look, my dad is stuck in this process. My mom is stuck in this process. Can you help me out, Senator? Now, they don't have to be voters. They have to be living in that to make an effect. Please try to make an impact in a fashion that will affect the heart of the person. These senators are human beings. They will get affected, and this is a miserable situation which you and your family is going through. And all you're asking is just to treat you like equal, no difference, that's all. So try to approach in a letter format, having your teenage kids write letters and yourself write letters to senators. And have all your friends write letters. Whenever you have a family gathering, sit down everybody. Have everybody write a letter to the senator. Post it out. it can be done, it can be achieved, and that's the only thing we can do at this point of time.
Nancy from Facebook is in a tough situation. Her husband's on H-1B and filed a transfer several months ago that's been pending this whole time. Finally convinced the company to upgrade it to premium processing, and now he's learned his contract is ending with that company. I-94 has already expired and the H-1B is still pending. Definitely a tough situation to be in. I would see if the company is willing to hold off on withdrawing the H-1B that's pending in the hopes that maybe you'll get an approval in the next few days, since the premium was upgraded just on January 7th. If you can get that approval, then your husband is immediately in the 60-day grace period and has 60 days to try to transfer to another employer.
Mohammed Siddiq from YouTube has this question. Both he and his friend have submitted a 485 application in July. Both of them got in 2019. Both of them got fingerprinted in 2019. His friend got the green card approval after the interview, of course, in December 2019, but his is still pending. Is there anything he can do? Unfortunately, nothing can be done. At this point of time, the online status says that it's about 16 to 18 months pending. So not much can be done. You can't raise a service request because it's within the normal timing. Yes, it is true that some cases do go through swiftly, some cases don't. The USCIS implemented the theme where they said that the 485 people can be interviewed at a different location, but we haven't seen that happening. I've seen the same situation like what you're saying, Mohammed. Nothing can be done at this point of time. You just have to wait. Just because your friend got it, that doesn't entitle you to do anything to get better.
Karthik from YouTube has a good follow-up question on our Nunc Pro Tunc discussion. He wants to know, what if the Nunc Pro Tunc gets denied and I leave the country, go for visa stamping and come back? Does that gap in the I-94 affect my green card process in the future? So that's where the 180 days comes into play, and why we would say if you're not going to get the decision on the Nunc Pro Tunc before you're hitting your 180-day mark, the best thing is to leave the country and wait for the decision outside the U.S. So assuming that you file your Nunc Pro Tunc request and you get the decision denying the request and you're still within your 180-day period and you leave, then there's no impact on the green card processing, because the inadmissibility is if you have been unlawfully present for 180 days or more. Here it's been less than 180 days and you were able to correct the error by getting a new visa stamp and come back to maintain your non-immigrant status. When you're filing your 485, they look at from your last date of entry going forward, have you consistently maintained your status? They don't look back previous to that. So it would not have an impact on the green card process.
Mohammed has this interesting question. It's definitely a good question, that his wife and he are living separately and file the adjustment of status. Will it complicate the 485? Mohammed, the way you said is complicated, but actually the way I read is that it's because of the employment. She is staying at a different location though. Yes, it does complicate though. However, the way, Mohammed, I read you and your wife is that both of you must consider either the place where you are living it or the place where she is living it. You can consider any of them as the main place. Now, I have had situations where people travel. When they travel, they can even travel a 1 month period outside the country. It depends on whether or not, if your wife considers your place as a home and she is traveling there and monthly only once she is coming, that's fine. It depends her mentality. What is her residence? What is her home? The reason why they want to give you the green card is for you to live together. But if you're saying that you are living separately, it complicates though. I normally speak with the wife and husband. I speak with them, hey, which one is your home? This one or that one? Which you consider as a main? And then I say, is there any problem that if I say that you live with your husband, but you're actually traveling for a 3 months period once and then coming back to the other place? And say, no, they don't have any problem. Then I use the same address. But it depends on what your mind is thinking. If you think so that you are living separately, then of course there's not much we can help you. But if you think so that, yes, my husband's home is my home, I'm actually only traveling here, you may be traveling for 3 months, that's perfectly all right, and going back. So that's the reason where I normally like to speak with the wife and husband and then see if they could say that one of their house is their main home, the other one is what they're traveling. And I've seen situations that I know people who work in Middle East, they never consider Middle East as their home. They always consider my village, where I come from, as their home. What is your home? They always say my village. They don't say Dubai, and that's the way they are. So in that case, the home, my village, is actually their residence. So you can speak with your lawyer and then come to a conclusion. That will be a better way of avoiding the problems.
Amit from Facebook has a tricky situation with his H-1B. He received an H-1B extension with his current employer till 2022. At the same time, he had filed a transfer with a new employer, and that only got approved until August of 2020. And that approval came after the longer approval. He's not joining that new company, but with the last action rule, he needs to know what does he need to do. So the last action rule is not necessarily an official rule. It's more of an unwritten rule that we see a lot of times immigration does not actually follow it. That being said, the safest thing that you can do would be to travel out and come back in with your first employer's longer approval notice to get a new I-94 that's valid till May 2022. That completes the new last action and fixes the issue. That would be the safest way to fix that problem.
Rahul from YouTube has this question. One of his friends has applied for the Farmington University but never joined. He's going for H-1B stamping. Will that be an issue? Rahul, your friend need to be screened very carefully. What do you mean by applied? What were the conversations that you had with them? What were the conversations you had with the agents? Was there any email communication between the University of Farmington and you? Because we are making some statements, the ICE is releasing videos that are contradicting to some of the statements we are making. So we need to know what was the conversations that went on between your friend and the University of Farmington. Anybody who has ever been touched with the University of Farmington, they need to get screened by a lawyer, because the USCIS has noted all these people and they put everything in their files. That's very clear. So if they have ever applied also, I would still want this guy to be screened by a lawyer to make sure everything is okay.
Karthik from YouTube wants to know if you need to file an amendment if the client is changing, but it's within the same MSA. So this is referring to the matter of SIMEO guidance that comes from USCIS about when an H-1B amendment is required. It is clear that an amendment is required when the work location changes outside the MSA for which the LCA was approved for. MSA referring to the metropolitan statistical area, or like the county, the commutable distance from where your LCA has been filed and certified. Now, changing clients within an MSA may or may not require an amendment, and that is going to boil down to, is that a material change? Are you going to this new client and it's the exact same job duties, same wage, nothing's really changed? Then potentially an amendment may not be required if there's no material change in employment. If you're going to this new client and you're going from your job duties are completely different, your salary is changing as part of that project change, then an amendment may be required. If you are going for stamping after making this change, I would definitely recommend an amendment being filed before you attempt going for visa stamping.
Ranjit has this question. Can he move from EB2 to EB1? He worked for 15 years for this organization, but in 11 years in USA and previous to that in India, and recently he has gone to India and worked for 10 months and came back to USA. For you to qualify, you must have worked at least for 12 months as a higher level manager back in the country that you worked, in India that you worked. So if your previous 4 years that you worked as a not like a higher level manager, that doesn't count. The 10 months that you spent in India may be counted if you worked as a higher level manager. but 10 months is by itself is not enough. It must be 12 months. There is also a lot of other requirements for a EB1C category, whether or not both organizations meet the qualification requirement, what is required for L1A, which the same thing is required for the EB1C category, that whether the ownership is meeting the requirement. Did you got the payroll from the India? Is it like where you're still on the payroll of USA? That may not be considered that you work there in India. You might have visited there in India. So I would have this thing reviewed by a lawyer before you go and take before you go and do anything. I would have to. But I think so it is worth for you to consult a lawyer. Because if 2 months is left out, maybe you would like to go back to India and work for 2 months and get the qualification and see if the EB1C works for you.
Himadri from YouTube has a pending change of status from F1 to H4 and now wants to apply for a J1 visa and wants to know if he leaves to go for stamping for the J1 before the H4 is approved, will the stay be unauthorized for that time while the H4 is pending? No, it's not unauthorized. So when you timely file a change of status from F1 to H4, you are then in what's called a period of authorized stay based on the pending application, and you remain in that period of authorized stay until it's approved. If you leave before it's approved to instead apply for a different type of visa, your change of status request will be abandoned, but that time it was pending is authorized because you are in a period of authorized stay, also referred to as POSABAG, period of stay authorized by the Attorney General.
The question that comes from Mehul is that he got recently married and his wife came from India on H4. Can she apply for the H4 EAD? Absolutely. Even though she was not listed on the I-140, she can. If your I-140 is approved, she can definitely file for EAD. Another question that pops out about the H4 EAD, when it's going to be taken off, when is the right time to file it? Well, if you are eligible, file it, period. No questions asked. You should. I have no reason for you. Now the question pops up is that when will the H4 EAD be taken off? We've been telling that it's coming in the next 3 months, but we've been telling that from past 1.5 years, which is actually a good thing. It's been coming for the next 3 months. We've been telling for 1.5 years. The administration has a proposal to take the H4 EAD off, but it still is a proposal. But recently, they're telling that it's going to come in March of 2020 now. A lot of people ask what will happen to the existing EADs, what will happen to the applications that are pending. This is a guess that I am making based on the previous EADs that we've been given to the undocumented kids that came under 15. We call them as DACA kids. Is that they said 2 months from now or 3 months from when the executive order was been issued, you cannot file any more EAD extensions. So practically for the people who are already there, the pipeline applications, they could go ahead and approve those things. Only 2 months after the notice has been sent, they said. We're assuming that when this regulations are going to come up, they're going to show the same courtesy what they showed to the other people. Also for the EADs that are already existing, it may be difficult for them administratively to take the EADs off because it may not be, it's not that easy for them to take the EADs off which are already given. So that's the estimate that we are making. I may be wrong, but keep tuned. I mean, every week we come in. If there's any update on the H4 EAD regulations, of course we're going to tell you the things.
And remember, just when the proposal is announced, it's still just a proposal. So while all of that regulatory process is going on, which generally takes several months, if not longer, you can continue to file, receive approvals, and maintain your H4 EAD. Sujana from YouTube wants to know if an employer can file an H1B while an H4 in EAD renewal is pending and the current EAD has expired. So I'm assuming that you're talking about filing in the CAP, and there's no issue with that. So the only issue is if you're intending to file the H1B as a change of status, which will take effect from October 1st, in order to be eligible for the change of status, you have to be able to show at some point that your H4 was actually extended to at least September 30th. So you may want to consider requesting consular processing in your H-1B petition if the H-4 renewal might take too long. That's one option. Or you could request the change of status. You'll get a request for evidence on the H-1B asking for proof that the H-4 was finally approved, and you'll have time to submit that back to them. But no issue, there shouldn't be any issues with filing the H-1B in the lottery.
Savi has this question. His EAD extension is pending. And this, I want to make it clear, Savi is speaking about adjustment of status EAD extension, not the H-4 EAD. Just adjustment of status, employment-based immigration extension of status. If the EAD is pending, and if this is for the extension, if your EAD expires, you're allowed to work up to 180 days after the EAD expires. So that's a good benefit that they have given, especially with the delays, what's going on.
Sunal from Facebook wants to know if someone can start the H-4 EAD process for the spouse who's not yet in the U.S. Unfortunately, no. That they do have to be physically present in the U.S. in H-4 status on the day that the EAD application is filed in order for that to be processed. So you'll have to have her here on H-4 first, then file the EAD. Once it's filed, she could potentially go back to her home country and wait for it to be approved if you wanted to go that route.
Jitendra has this question. Is the 2021 pre-registration H-1B, what is the benefit? I'm assuming when he says 2021, he's speaking about the financial year, which starts on October 1st of 2020, where we have to file the application in April. That's the only way. I mean, you have to register for you to get into the lottery system. If you don't, you can't file a H-1B application. So you have to register between March 1st and March 20th. If you don't, that's it. You can't file an application. No way around it. You can't come back to us on March 31st and, hey, I didn't register in the lottery system. Can you file a H-1B? The answer is no, you can't.
B from YouTube had an H-1B approved until August, along with an H-4 and H-4 EAD for his spouse. Filed a transfer and got an approval till only March. So had the approval till August, but now transferred and got a shorter approval. Didn't file the H-4 and the EAD along with that transfer. So they still have a valid approval till August 2020. Wants to know if the H-4 is automatically shortened to the March 2020 date of that new approval notice. No, it is not. So the H-4 is not tied to a particular employer or a particular approval notice. It is tied to you as an H-1 holder maintaining your status. So assuming that by March 2020, your new employer has filed an extension and gotten that approved, your wife's H-4 remains valid until it expires in August 2020 along with the EAD.
Anita has this interesting question. She has a H-1B approved for 3 years. Now she's going to file an amendment. What if the amendment is shortened up? Can she go back to the previous end client and work for the 3-year period? Or does she need to file another extension or amendment? Anita, no, you don't need to file any other amendment. You can go back to the old job and you can work. So let's say, for example, your H-1B is expiring in 2022 October or September of 2022, and your amendment is only approved until, let's say, June of 2020. You can go back to the old end client. You can continue working until your H-1B expires. You don't need to notify USCIS. You're good. You're fine. Absolutely no problem.
Let's see here. Sundeep from YouTube says he received a 3-year extension recently of the H1 and H4 and H4 EAD, and so when he files his transfer coming up soon, he's planning to not include his wife's H4 and EAD in it, and wants to know if she'll be able to use his new approval notice when it comes for the transfer when she goes for her future H4 stamping. Yes, it's not mandatory for her to file the H4 or EAD along with your transfer because she already has a perfectly good one and she'll be maintaining her H4 status as long as you're maintaining your H1 status. And then she can use that new H1 approval notice when she needs to go for stamping. No issues.
Question came, are there any other live sessions that we do other than the every Tuesday at 5 a.m. This question comes from Facebook from Nikhil. Yes, we do. Every single day we allocate 30 minutes. The link is provided at the bottom of the description in there. Every day at half an hour, it's a free conference call. You can call in, dial in, ask any questions. There will be questions and answers on the phone. We're not going to present anything. It will be Q&As, that's it. We answer about 30 to 40 people every single day on that. You can also listen to those podcasts at iTunes and Spotify. Just type in Reddy Neumann PC, and then you will find these podcasts that we do every single day. We do conduct a conference call. It's free. It's for half an hour. You can come and log in and speak.
Maybe one last question here. Soru from YouTube was on H-1B and unfortunately lost his job in November. And filed a change of status to H4 by December 12th within the 60-day grace period. He's gotten the fingerprinting done, has the receipt number, but of course it's still not approved. He wants to know if he can stay in the United States. And the answer is yes, because that H4 change of status was timely filed while you were in the 60-day grace period. I'm assuming that your H-1B I-94 was still valid when you lost your job and was valid beyond December 12th. For the 60-day grace period to apply, your I-94 has to remain valid for at least 60 days. But as long as you timely filed that change of status, that puts you in a period of authorized stay, and you can remain in the U.S. based on the pending H-4 as long as it stays pending.
Thank you guys for tuning in. Don't forget, we do have a daily conference call. Don't forget to subscribe to immigrationgirl.com of Emily's blog, and also rnlawgroup.com news section.
And we do provide consultations as well. So if you want more detailed information about the specifics of your case, you can set up a consultation online easily by going to rnlawgroup.com and click on consultation. There you'll be able to see all of our attorneys' profiles and what their areas of expertise are. Select your attorney, select a time that's convenient to you, and get it all set up there.
Thank you guys for tuning in.